Wilson, come on up. Yes.
No just motion to sub today, huh?
Not today.
Wonderful. Good morning.
Good morning.
And who do we have here?
Marissa Wilson.
Good morning, Ms. Wilson. All right, Ms. Wilson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am.
On September 7th, 2024, officers observed defendant's vehicle traveling 35 miles per hour in a 60 miles per hour zone between 7400 and 8400 block of Katy Freeway in Harris County, Texas. Officers observed defendant also almost hit an 18-wheeler traveling to the defendant's right, and the defendant almost swerved into another passing vehicle. Officers observed the defendant's registration to be expired as of November 2020, and a traffic stop was initiated. Defendant came inches from hitting the freeway wall while exiting, and the officers made contact with the defendant, the driver, and sole occupant of the vehicle. Officers observed a strong odor of alcoholic beverage, glossy eyes, and slurred speech. Defendant stated she was going home and had 5 alcohol. And was 4 at 4. The defendant read the DIC and refused breath. Officers located a half-empty 750 milliliter Jägermeister in the defendant's vehicle. A blood search warrant was obtained and executed. The defendant was identified by her Texas driver's license.
Did you say initially, did I hear you that you said she had a suspended license?
She had a registration expiration.
That's what it was. Okay.
Yes, Your Honor.
Where was the Jägermeister? Was it within reach? So she's drinking while she's driving?
I'll check, Your Honor. Let me read the OR.
Yeah, take your time. While he's doing that, Ms. Wilson, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using anything, I'm going to put you in jail. You will not get any more PR bonds, ma'am. You have a valid Texas driver license. You're not allowed to drive. And I want you to understand that I don't think anything makes me more upset than we have people driving like boneheads out there without a driver's license. And I'm going to tell you now, if I find that you drive, I will bring the wrath so hard that I'm going to sprout horns in the tail. That's how upset I'm going to be.
Your Honor, the OR just says inside the defendant's vehicle was a half-empty bottle of Jägermeister. It doesn't say where specifically.
Okay. Ms. Wilson, you will be signing an affidavit with me today. I don't care what's going on in your life. I don't care if there's an emergency. There's nothing you can tell me that you can justify getting into a car and driving whatsoever. If you want a license or if you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, don't do it. I don't care how tempted you are.
This is a textbook DWI fact pattern prosecutors love. Near miss driving, visible impairment, open alcohol, and a refusal to take a breath test. Legally, refusal isn't a get-out-of-jail-free card in many jurisdictions. It actually strengthens the state's case because it can be argued as consciousness of guilt. And notice something important. Even a half-empty bottle inside the car can escalate perception from simple impairment to active drinking while driving. So the real question is, how much doubt can the defense even realistically create here?
Let me ask you this. I asked you if you have a Texas driver's license. Do you have a driver's license from anywhere else? Okay, then that's what all right. I'm going to have you come up here, swear to us that you're not going to drive. After that, I'll get you to Victoria. We'll have you sign a reset. You'll get with Rachel for your bond conditions, and then after that, you're free to go. No drinking. Don't drive. Okay. Thank you.
Thank you.
All right, Judge, page 1, Cabasas.
And we're going backwards. Abbas, come up.
I'm sorry, is it 12?
Good morning, Judge.
No, it's not. It's not. It most certainly is not.
This is where the courtroom tone completely shifts into deterrence mode. The judge isn't just deciding this case, he's sending a message to every future defendant in that courtroom. That wrath language might sound extreme, but in legal psychology, judges often use strong verbal framing to reinforce compliance with bond conditions. In simple terms, this isn't just punishment, it's behavioral control through fear of consequences. The question is, does this actually reduce repeat offenses or just escalate tension in the courtroom?
It's a morning. Good. I guess that's a matter of perspective. You tell me here in about 5 minutes if it's good. Mr. Abbas, you picked up a new case while you're on bond. You're now charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 9th, 2024, officers were dispatched to 3506 Fern River Drive on a call for stating that the defendant was banging on the door and refusing to leave. The defendant was sitting on the porch when the officers arrived, and the defendant stated he was arrested the other day for criminal trespass at this location, and he wanted his phone and keys back. The officer knocked on the door of the residence and did not get a reply. The officer told the defendant that he should not be at the residence, and the defendant began to walk away. Officers reached out to the complainant via cell phone, and the complainant and a witness came to the door. The complainant, the homeowner and mother-in-law of the defendant, stated she did not want the defendant on the property due to him being a drug addict. Officers returned to his shop and discovered that the defendant had returned to the scene. Officers detained the defendant and was given a trespass warning.
So let's go through the timeline. He picks up. Okay, so he picks up an interference and then a felony possession case, right?
Yes, Your Honor.
Gets out of jail. It goes right back.
Yes, to the residence, yes.
Had we ordered him not to go back?
If you look at the bond conditions, Judge, let me see what was ordered.
I mean, regardless, he picked up a new case.
He did pick up
Right.
a new case while I'm
So guess what happens now that you picked up a new case? Want to take a guess?
I have no clue.
Take a guess. You should be able to hear it behind you. I am now revoking your bond and I'm taking you into custody.
Judge, I would like to say is that,
There's nothing you can say right now. You picked up a new case and I told you not to pick up a new case. So he goes with you. I'll appoint your lawyer now. You can tell the lawyer. It's not a good day though. Okay.
All right, Judge, page 5. Coey,
So 5,001 on the interference and then ixnay on the PR bond A on the criminal trespass A. A. If they give me a PR bond. Let's see. Yeah. Yeah, they give him a PR bond, so no dice on the PR bond. Shatoria, can you do me a solid? Set him up for T-Rans, please, on Abbas,
Abbas.
please. Vic, what page?
This one is on page 5.
And just like that bond revoked, this is one of the most serious turning points in pretrial proceedings. Once a defendant picks up a new case while already on bond, judges have extremely wide discretion to revoke release immediately. No jury, no trial, yet just a finding that conditions were violated. That's why the judge doesn't hesitate here. But here's the tension. At what point does pretrial supervision become punishment before conviction?
Top of page 5.
Thanks.
COH.
Correa. Mr. Correa, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Okay. On September 5th, 2024, the officer observed the defendant's vehicle traveling at a high rate of speed, 89 miles per hour in a 65 mile per hour zone at 3900 block of East Sam Houston Tollway in Harris County, Texas. The officer observed the defendant's vehicle swerve through traffic to maintain high speed and move from lane 2 to lane 3 to lane 1 in a reckless manner without signal, causing other vehicles to brake. The defendant's vehicle came close to colliding with other vehicles while changing lanes when unsafe to do so. A traffic stop was initiated. Officers made contact with the defendant, the driver, and sole occupant of the vehicle. The defendant was ID'd with his Texas driver's license.
Mr. Correa, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? Do you have liability insurance in your name? I want proof before you leave here for today. Otherwise, I'm not going to let you drive. I'm making it a condition of your bond that you not participate in any more reckless driving, street takeovers, racing, boneheaded moves of this nature. Otherwise, the first thing I'm going to do is I will take away your privilege to drive. The second thing I'm going to do is I will put you in jail, just like I did this past person. Do you understand?
Sir.
Do you mind filing those conditions, please? Correa. Correa. C-O-H. No reckless driving and all that jazz. Reckless driving, racing, street takeovers, etc. For now, I'm going to have you go to Victoria. I'm going to have you sign a reset. After that, I'm going to have you take a seat in the jury box while we wait for your lawyer to get here.
All right, Judge, next is page 5, Cormier.
So on this gentleman,